A dramatic change in heart for a one-time university employee who now admits she had sex with a 15-year-old boy. But in entering a guilty plea, she's sentenced with only 6 years of probation.
Every defendant thinks that they're smarter than the average bear and that they're not susceptible to being caught. This is why they're criminal defendants.
You first heard about the story on Law&Crime's Sidebar podcast back in July, when Jesse Weber told you about the arrest of Stephanie Neipling, a University of Arkansas employee. According to court documents, Neipling had sex with a 15-year-old boy in Rogers, Arkansas on July 8th. Officials say Neipling was sitting on a couch next to the boy when she moved his hand into her vagina. Court documents say, quote, later on that evening, Stephanie had sent him a message via Snapchat stating that he could come next door to her friend's apartment because she was alone there. He went back over and he had oral sex and sexual intercourse with Stephanie. The next day, Neipling, quote, messaged him nude photographs of herself and messages sexual in nature to include asking him how his experience was the evening before. Arkansas investigators were tipped off about this incident via a hotline on July 11th. When they interviewed Neipling, she, quote, initially denied the allegations made against her, but later admitted to having sexual intercourse with the boy. At the time, Neipling's bond was set at $50,000 and she was ordered no contact with the boy. She initially pleaded not guilty to a fourth-degree sexual assault charge, but just this week, she changed her plea to guilty. For that, she was sentenced to 6 years probation and 116 days behind bars, which she's already served. Former prosecutor and criminal defense attorney Florina Altschiller tells Law&Crime Network Neipling's plea may have been made to benefit the 15-year-old victim.
There's a lot of factors that a prosecutor would consider in deciding what kind of a plea offer to make. Oftentimes, the biggest consideration, especially in child sex abuse cases, is whether or not the victim is somebody that is going to be able to testify, how well they will testify, and whether or not the trauma that will result from that person having to testify is essentially worth it in the long run. So if they could get a defendant to change their plea, to take a guilty plea, and if the sentence is something that the victim and the victim's family is happy with in exchange for avoiding having to testify, then oftentimes that's a good and fair deal for everybody involved. And it's a consideration that's going to change depending on the case, right? Not every victim's the same. Not every victim's family is the same. The facts are not always the same. And the outside evidence that may or may not corroborate what the victim said is going to be different. The less outside evidence there is, the more dependent the case is going to be on the victim to testify, and the more likely a prosecutor is willing to give a defendant a better deal to avoid having to expose that victim to the trauma of testifying.
So in this case specifically, let's say that Neipling had kept that not guilty plea and it does go to trial. Do you believe in this case that 15-year-old boy's testimony would have been vital in the case?
Absolutely. There's no way to convict her of having sex with him without him testifying. And testifying is not an easy thing to do. He would be subject to cross-examination, and he would have to, in great detail, relive the trauma of what happened in front of a jury of strangers from the community. So there's always that balancing scale of whether or not a prosecutor wants to expose a victim, especially a minor, like in this case, to have to testify.
But before a change in plea came a change in Neipling's story. What I think was kind of interesting about this is that after her arrest, she initially denied that she had sex with this 15-year-old boy, and she also initially pleaded not guilty. So why do you think there was this change that she eventually admitted it and then pleaded guilty?
Pretty much every defendant initially pleads not guilty, and they have the right to do that because the burden of proof is with the prosecution, and the prosecution has to prove beyond a reasonable doubt the allegations that they allege. Eventually, there's often a plea deal or an offer made. And in order to accept that offer, what a defendant has to do is they have to change their plea from not guilty to guilty to take advantage of whatever the offer is. Most of the time, the offer is for a reduced sentence and a reduced charge.
When it comes to a change in plea, Altshuler says prosecutors likely offered Neipling a plea deal. So when we're talking about a plea deal here, what would that look like between her team, the defense, speaking with prosecutors and trying to come up with an arrangement?
Usually what happens is the prosecution will offer at least a one-step reduction, sometimes even more of a reduction. Sometimes it's reduced from a felony charge to a misdemeanor charge, and then the sentencing range is significantly less. So maybe someone's looking at 7 to 15 years in prison. The plea offer is to a charge that would expose them for 3 to 5 years in prison, or maybe they're looking at a multitude of years and the plea offer is just for 1 year. So the incentive to then plead guilty is that reduction of prison time that the person would be looking at in terms of sentencing.
But rather than spend any more time behind bars, Neipling will spend 6 years on supervised probation instead.
So probation's going to be a little bit different in every state, but generally speaking, especially in a sex assault case involving a minor, there are special sex-related conditions. Oftentimes, they have to stay away from minors. They cannot work a job that involves contact with minors. They cannot live within a certain distance of a school. So there's going to be restrictions on what kind of housing is appropriate. They're going to have to check in with probation every so often. They're going to have to keep their address current. Sometimes there's conditions that they can't use the internet or can't use social media, can't have contact with minors. And that's ultimately a determination made by probation in terms of what specific conditions apply. But many of the conditions are sex-related conditions and minor-related conditions. And of course, if the defendant violates those probation conditions, they could be subject to resentencing for violation of probation.
Altshuler says while the sentence may seem light to some, it's the goal for Neipling to learn from her mistake.
Obviously, this is a fairly low sentence, right? She got time served. She's not going to prison. She has these probation conditions, but what you want to think about is the balance between punishment, avoiding recidivism, sending a message to society, but also making sure that the person has an opportunity to reform or correct their behavior. And so when you have somebody who has no prior criminal history, no history of committing this type of offense in the past, the idea, hopefully, is that they're able to re-enter the community and live a law-abiding life and not reoffend. And that's why you have such a long probation term with significant conditions. And if she were to violate those conditions, that she would potentially be looking at a significant prison sentence for violating those conditions. The balance there is if she is able to follow those conditions and not violate those conditions, then in theory, society achieved what it wanted to achieve, which is somebody who's not reoffending and somebody who's living a law-abiding life. Most of the time when people have a criminal history, and when this is their second, third, fourth offense, the sentence becomes more and more harsh. Here, for somebody without a prior criminal history, the DA's office and the court were pretty lenient, but they're often pretty lenient with first-time offenders.
As Altshuler points out, Neipling's is not the first case of its kind.
I think we're seeing more and more cases in the media of female defendants committing sex offenses. And the general view in society is that men are rapists and women are not, and that male victims wanted it. And that is absolutely not a good way of looking at things, because what we're looking at is children who are victims. And so regardless of gender, when you have a 15-year-old, a 15-year-old is not capable of consent. And so this view that just because we're talking about a boy versus a girl, that the boy must have wanted it, is really harmful to society and really harmful to our culture. And I hope that as we move further in society and evolve our way of thinking, it's not going to be a surprise that there's a female defendant, because what we will recognize is that we have a child victim, and a child is simply not capable of consent. And the gender's irrelevant, and whoever is abusing this child is committing a criminal act, and gender does not equal consent ever. Age is the pivotal question here.
Just last month, we told you a story similar to Neipling's about 25-year-old Ricky Lynn Laughlin of St. James, Missouri. Laughlin, a high school teacher, now faces 6 charges, including attempted rape of a 16-year-old boy. She's accused of sending the boy illicit photos and videos via Snapchat, later telling him to delete the pics because she could go to jail if they were found. Prosecutors also say she invited the boy over to her house to have sex when she knew her husband would be out. We also covered the story of Alyssa McCommon, a former Tennessee teacher accused of raping a 13-year-old student in her own home. Investigators say she used video games and social media apps to communicate with multiple students. After being released on bond, she was arrested for a second time after prosecutors say she contacted the 13-year-old boy she allegedly raped. According to a recording later played out in court, McCommon is allegedly pregnant with that boy's child. There's also the case of 24-year-old Cassidy Krause, a teacher in Iowa, accused of having sexual interactions with at least 3 underage students. According to officials in Manning, Iowa, Krause allegedly sent explicit photos, molested and sexually abused 13 and 14-year-old students. We also reported on the case of Peyton Shires out of Ohio, a newly credentialed social worker accused of sexually abusing a 13-year-old boy she'd been assigned to counsel. When investigators searched the boy's phone, they found videos of him and Shires having sex. She later allegedly threatened to kill both the 13-year-old boy and his mom when she brought a gun to their home. I've done multiple stories like this recently. I would say 10 to 12, maybe more than that. And I keep seeing a pattern where a lot of the perpetrators are using social media, oftentimes Snapchat, and then they're sending these naked or explicit photos. Can you explain that to me? Why does this keep happening? I mean, they're leaving a trail of evidence here.
In the age of technology, this is the new way that sexual predators are grooming their victims. Young people, especially young teenagers, are using social media to communicate and interact, and they're on it pretty much all the time. So if you want to have contact with them and you're a sexual predator, unfortunately, this is the way to have contact with them, to make them comfortable, to lure them in, and then to casually start introducing a sexualized way of communicating. And if they're receptive to that, that's where the physical contact is then introduced. Before technology, actual interaction was required, right? There was no social media to interact with minors. And so you saw a lot of cases of Boy Scout leaders and teachers and people who had physical access to youth abusing them. Now that's no longer as necessary because people in the community have access to youth through social media. And I think that's why it's super important for parents to really be on guard and really be aware of what their children are doing on social media, who they're communicating with, what apps they're using, and what the nature of those communications is, because sexual predators are savvy. They lure their victims in through social media, they groom their victims through social media, and then they create opportunities for physical abuse.
Prior to her arrest, Neipling tweeted a picture of her writing, quote, "Wear blue for child abuse." Altschiller says Neipling and other defendants often believe they'll get away with their crime.
Every defendant thinks that they're smarter than the average bear, and that they're not susceptible to being caught. This is why they're criminal defendants. If they thought they were going to get caught, if they had guilt, and if that break in their brain worked to stop them from doing this, they wouldn't have done it. So obviously, somewhere in their head, they're thinking that either this conduct is okay, or they're normalizing it to themselves to make it okay, or they're cognizant enough to realize that this is not okay, but they feel like they're above the law and they're going to get away with it. That's a common theme amongst all criminal defendants. Nobody is committing a crime, feeling guilty about it, and thinking that they're going to get caught immediately. If that was the thought, they wouldn't have done it.
When it comes to future situations like this, Altshuler says it's important to keep an open line of communication between parents and their children.
Look, unfortunately, there is no way to definitively prevent things like that. But awareness goes a long way to help prevent things like this. Having honest conversations with your children about appropriate and inappropriate contact, about adults who maybe don't have their best interests in mind, and about communications that could expose themselves to vulnerability in the future. The other thing to consider is minors are putting photos of themselves out there on social media. And that's something that 20 years from now, they're going to seriously regret and is not going to be easy to erase. And so all parents should have honest and open conversations with their children about the conduct that their children are exposing themselves to and the conduct that not well-meaning adults are going to expose them to, because social media is here to stay, and it is the new way that people are communicating constantly, and it exposes people to risk, and that is a risk that people should be well aware of.
But above all, no child under the legal age of consent can give consent to have sex.
Their brain has not yet developed enough to be able to make conscious decisions about whether or not they can consensually, willingly engage in sexual activity. That's why we have laws restricting access to alcohol, access to tobacco, whether or not you're allowed to drive, whether or not you're allowed to vote, if you can join the military. Those are all age-based restrictions because we recognize in our society that the human brain is different when you're an adult versus an adolescent versus a child. And so given the limited functioning of that brain as a youth, consent really is not something that's an option that's available at that age. And so even if a child says, oh yes, this is a great idea, they are legally not capable of consent, and an adult must know better.
Right now, there are 38 states with the legal age of consent under 18. In Arkansas, where this crime happened, the age of consent is 16, with a maximum age gap of 3 years between the people consenting. That means even if the boy was a year older and could have given consent, it still wouldn't be legal because of his 26-year age gap with Neipling. From here, Neipling will register as a sex offender and is no longer allowed to maintain contact with the boy. Reporting for Law&Crime Network, I'm Gillespie.